Okay, let's just jump right in with something pretty explosive. Imagine this. You've got a senior Justice Department official, someone nominated for a judgeship, apparently telling staff that if courts try to block deportations, the DOJ might just have to tell them, and this is a direct quote, they're alleging, fuck you.
Wow. Yeah, that's the kind of claim that makes you stop and really pay attention. And it's central to what we're digging into today.
Exactly. We're doing a deep dive into this really detailed 27-page whistleblower disclosure. It's from Erez Reuveni, who wasn't just anyone. He was a long-serving, highly respected immigration lawyer inside the Department of Justice.
Right. And his disclosure, it paints a really troubling picture. We're talking alleged misconduct, stonewalling, even potentially misleading federal courts, all coming from the top leadership at DOJ, specifically around some very contentious immigration policies.
So our goal here is to unpack what Reuveni is alleging. We'll look at the key claims, see what public information might back some of them up, and importantly also cover how the DOJ is responding to all this.
Yeah, because they have responded quite strongly. So this is really your shortcut to understanding a pretty complex story that's still unfolding, one that hits right at, government accountability and the rule of law.
And by the end, you should have a much clearer sense of three specific immigration cases that are key here, the ethical tightrope government lawyers might walk, and, well, what this all could mean more broadly.
It's definitely a look behind the curtain. Maybe a bit unsettling, but really important stuff.
Okay, so let's start with the whistleblower himself, Erez Reuveni. Who is this guy? Why does his background matter so much here?
Well, like you said, he wasn't just some random employee. He spent nearly 15 years at the DOJ, specifically in the Office of Immigration Litigation OIL.
15 years is a long time in government service.
It is. And he rose through the ranks. He was acting deputy director for OIL, which meant he was overseeing hundreds of cases, supervising other attorneys. His record, by all accounts in the disclosure, was exemplary.
So promotions, good reviews.
Multiple promotions, yeah, under both Republican and Democratic administrations. That's key. His superiors, people like Drew Ensign, called him things like a top-notch litigator, an indispensable asset. He consistently got excellent ratings.
And awards too, right? I saw mentions of several civil division awards.
9 of them, apparently.
Yeah.
For work on some really high-profile, tough issues. The COVID immigration response, sanctuary cities litigation, defending the Trump administration's foreign terrorist entry executive order.
So defending controversial policies wasn't new to him.
Not at all. And that's maybe the most crucial point about his background. He defended the immigration priorities of the Obama administration, the Trump administration, and the Biden administration. The disclosure stresses his commitment was to his oath to the Constitution, advocating zealously for the government's position regardless of who was in the White House. It paints him as nonpartisan in his legal work.
Okay, so you have this veteran DOJ lawyer, stellar record, experience across administrations. What allegedly pushed him to file this whistleblower disclosure?
The disclosure itself, filed June 24th, 2025, so very recently, went to Congress, the DOJ Inspector General, and the Office of Special Counsel. It lays out what Reuveni claims are violations of law, abuses of authority, and serious risks to the safety of non-citizens caught up in these policies.
How has the DOJ responded? You mentioned they reacted strongly.
They did. Deputy Attorney General Todd Blanche came out swinging. He called Reuveni's claims falsehoods, dismissed him as a disgruntled former employee, and labeled the disclosure a false hit piece aimed specifically at Emil Bove, who, as you mentioned, is up for a judicial nomination.
That's a very direct pushback. Disgruntled former employee is a common defense in these situations. Does the disclosure offer anything to counter that beyond Reuveni's own word?
It suggests it does. Reuveni indicates there's a substantial paper trail, emails, texts, phone records that could potentially back up his account of these events and conversations. So it's not just presented as his memory versus theirs. He's pointing towards potential evidence.
Okay, let's get into that headline allegation then. The fuck you comment. This relates to something called the Alien Enemies Act litigation. What happened there?
Right. This is the case JGG v. Trump. And the timing is pretty striking. It allegedly starts on March 14th, 2025. That's the same day Reuveni was officially told he was being promoted to acting deputy director.
So a big day for him professionally.
You'd think so. But on that day, he gets called into this meeting with senior DOJ officials. And according to Reuveni, this is where Emil Bove made that alleged statement that the DOJ might need to tell the courts, fuck you, if judges tried to block deportations under the Alien Enemies Act.
What is the Alien Enemies Act? Briefly, it sounds old.
It is. It's a law from 1798, rarely used, that gives the president broad power during a declared war or invasion to detain or deport citizens of a hostile nation. The context here involved using it for deportations, which was legally contentious.
And Bove allegedly wasn't just venting. He said flights were happening soon.
That's the claim. That Bove indicated flights under the AEA would take off that very weekend, March 15th and 16th, quote, no matter what. Reuveni says he and others in the room were just stunned. The idea of openly defying a court order, it's just not something DOJ lawyers are supposed to contemplate, let alone plan for.
Okay, so that's the alleged plan. What happened over that weekend, March 15th and 16th?
Well, things moved fast. On Saturday the 15th, the ACLU files a lawsuit. They're representing 5 Venezuelan men facing deportation under this act. And they argue these men would be sent to prisons in El Salvador known for, well, torture.
So high stakes for these individuals.
Extremely high. Judge James Boasberg quickly issues what's called an ex parte temporary restraining order, or TRO. Ex parte means it happened fast, without a full hearing involving both sides yet because of the urgency. The TRO specifically prohibited the removal of those 5 named plaintiffs.
A direct court order. Don't deport these 5 men. What did the government do?
There was a court hearing around 5 p.m. that same day. Deputy Assistant Attorney General Drew Ensign, remember, one of Reuveni's former supervisors who praised him, represented the government. Ensign told the judge he didn't know if deportation planes had already left or if removal was imminent.
But Reuveni believed Ensign did know, or should have known.
Reuveni's disclosure suggests he believed Ensign's statement was false, especially given Ensign was allegedly at that March 14th meeting where Bove made the no matter what comment.
And what was actually happening with the flights?
This is where things get interesting. Public flight tracking data and news reports apparently confirmed soon after that hearing that 2 planes had departed from Texas after the hearing began and were heading towards El Salvador.
So, potentially in defiance of the judge's order, which was issued verbally even before the written version.
Exactly. And internally, Reuveni says he was scrambling, sending emails to DHS, the Department of Homeland Security, and the State Department, flagging the TRO, asking urgently if any of the 5 men covered by the order were on those planes or about to be removed. He stressed that anyone already in the air needed to be brought back.
Did he get answers?
Not initially, according to the disclosure, just silence. Eventually, DHS responded, saying they were waiting for guidance from the Attorney General.
Okay, so DHS is on hold. What about DOJ leadership?
This part is also quite complex. Ensign initially told Reuveni that Emil Bove would file a notice with the court. The notice would argue the TRO didn't apply because the planes took off before the judge's written order was formally entered, even though the verbal order came earlier. Reuveni actually drafted this notice based on Ensign's instruction.
But then they changed tack.
Yes. Ensign then allegedly told Reuveni that Bove had decided not to file that notice after all. This left Reuveni really worried because without that explanation to the court, the government looked like it was just ignoring the order, potentially facing contempt charges.
And then came Sunday morning.
Sunday, March 16th. The president of El Salvador, Nayib Bukele, posts on social media something like, "Oopsie, too late," along with a video. The video apparently showed men being marched into the notorious Seacot prison. It strongly suggested the deportations had happened.
Wow. Did Reuveni ever get confirmation internally?
Eventually, yes. An agency lawyer for DHS reportedly confirmed that DOJ leadership had initially told DHS to stop the flights and deplane the individuals, complying with the order. But crucially, this lawyer also said DHS and the State Department were getting contrary directions, implying orders from somewhere else to violate the court's TRO.
So conflicting messages within the government itself. How did the DOJ explain this to the court later?
A subsequent DOJ notice filed with the court claimed the relevant defendants were promptly notified of the TRO, but acknowledged some individuals were removed before the written order was issued, kind of glossed over the timing issues and the conflicting internal directions Reuveni reported.
And it didn't end there, right? The court wanted more answers.
The court definitely wanted more answers. On Monday, March 17th, there was another hearing. The judge ordered the government to explain exactly what happened with those flights.
And did they?
According to Reuveni, no. He says DOJ leadership, specifically mentioning officials named Flenchy and Ensign, directed him that the government would refuse to answer the court's questions about anything that happened before 7:26 p.m. on Saturday, the time the written TRO was filed.
So refusing to tell the court what happened during that critical period when the planes took off.
That's the allegation. A direct refusal to comply with a court's order for information. It suggests, again, a deliberate effort to kind of wall off scrutiny of their actions right around the time the TRO was issued.
Okay, stepping back from the minute by minute, the picture Reuveni paints here is one of potential direct defiance of a court order, maybe some misleading statements to the court, and then actively refusing to provide a full accounting when asked.
Exactly. It suggests a scenario where the policy goal carrying out these specific deportations under the AEA allegedly took precedence over the legal obligation to follow a court order and be candid with the judge. That puts career attorneys like Reuveni, who are officers of the court, into an impossible position.
And this wasn't an isolated incident, according to the disclosure. There was another case involving a different court order.
That's right. This brings us to the second major situation Reuveni details, the third country removals litigation. The case is DVVDHS.
What happened in that one?
On March 28th, 2025, so just a couple of weeks after the AEA events, a different judge, Judge Brian Murphy, issued another TRO. This one was nationwide. It blocked the government from removing individuals to third countries they weren't citizens of, without first conducting screenings to ensure they wouldn't face torture there.
A nationwide injunction. That's a significant ruling. How did DOJ leadership react this time?
According to Reuveni, the reaction was immediate. Appeal it. But they also decided to argue that the injunction wasn't actually nationwide, despite the judge's clear language.
How could they argue it wasn't nationwide if the order said it was?
This is where it gets quite specific. James McHenry, who was a counselor to the Deputy Attorney General, allegedly insisted they include what Reuveni calls an ambiguous footnote in their appeal brief. Reuveni came to believe this footnote was intentionally crafted to provide sort of legal cover if they knowingly violated the nationwide scope of the injunction later on.
So laying groundwork to potentially ignore part of the order. What about compliance on the ground? Did DHS get guidance?
This is another major point of contention. Reuveni learned, allegedly, from an unnamed administration official that DHS was specifically directed not to issue any internal guidance to its officers about how to comply with this nationwide injunction.
Wait, so a federal judge issues a nationwide order, but the agency responsible for carrying it out is told not to tell its own people how to follow it?
That's the claim. And Reuveni says his emails to DHS lawyers asking for updates on compliance guidance just went unanswered. He was even getting alerts from concerned DHS attorneys saying, yeah, no guidance has come down. You can imagine the chaos and legal risk for officers in the field.
Absolutely. What happened next? Did Reuveni keep pushing?
He did, but he ran into more resistance. James Percival, a senior counselor to the Homeland Security Secretary, allegedly told Reuveni to basically keep DHS out of it, and admitted that DOJ leadership couldn't even agree amongst themselves on a strategy for handling the injunction.
So internal disagreement and an instruction to Reuveni to back off.
And more pressure. Drew Ensign allegedly told Reuveni to stop sending emails about compliance to large groups of people, essentially. Stop creating a wide written record of the lack of guidance.
A sort of gag order.
That's how Reuveni seems to interpret it. But despite that, on March 30th, he kept emailing DHS, trying to get clarity on the guidance situation. And Dinah then allegedly told him flat out, leadership has decided no guidance will be issued, period, and Reuveni needed to stop contacting DHS about it. Full stop.
While all this is happening internally, what's going on with actual deportations or removal?
This is where it connects to a public event. On March 31st, the Secretary of State puts out a press release. It boasts about a successful counterterrorism operation. Part of this operation involved transferring 17 individuals described as violent criminals from Texas through Guantanamo Bay and ultimately to El Salvador.
Okay, transferring people to a third country, El Salvador. That sounds exactly like what the injunction was about. Did Reuveni look into this?
He did. He was concerned this might violate Judge Murphy's nationwide TRO. He contacted the Department of Defense, DOD, because Guantanamo was involved. He spoke to Charles Young, the acting general counsel for DOD.
What did the DOD lawyer say?
Young reportedly confirmed the timeline. The individuals left Texas on March 29th, went to Guantanamo, and then flew to El Salvador on March 30th. Crucially, Young told Reuveni he was completely unaware of Judge Murphy's nationwide injunction against third country removals. He was apparently quite upset that DHS hadn't informed DOD about this court order that could affect their operations.
Another instance of alleged lack of communication or maybe deliberate withholding of information about a court order?
It certainly looks that way based on Reuveni's account. And the alleged efforts to obscure things continued. A DOJ official named Roth later reportedly told Reuveni that Emil Bove was unhappy. Reuveni had been making these inquiries to DOD.
Unhappy he was asking questions about compliance.
Yes. and Roth allegedly directed Reuveni to communicate only by phone from then on. The stated reason, according to Reuveni, was to avoid creating written records that could be subject to Freedom of Information Act requests, basically, to avoid transparency. Roth also allegedly told Reuveni not to expect any answers about whether that transfer operation actually violated the court order.
Just don't ask, don't tell, and don't write it down.
That's the essence of the allegation. It points towards a potential pattern. Resist the court order, avoid issuing clear compliance guidance, potentially carry out actions that violate the order, and then actively try to prevent any documentation or answers about it. Again, a deeply problematic scenario for government lawyers committed to the rule of law.
Okay, this leads us to the third case, the one that Reuveni says directly resulted in him being fired, the Kilmar-Abrego Garcia litigation.
That's right. This situation also began around that same chaotic mid-March timeframe. On March 15, 2025, Kilmar-Abrego Garcia was removed to El Salvador, sent to that same CECOP prison. The key issue here was that his removal was apparently unlawful from the start. It allegedly violated a prior order from an immigration judge.
So an erroneous removal, does that happen sometime?
It does happen. Administrative errors occur. And Reuveni, who took this case on personally, believed it should have been straightforward. Standard practice for an erroneous removal is usually to acknowledge the error and work to bring the person back.
But it wasn't straightforward this time.
Not according to Reuveni. He says he immediately faced pressure to misrepresent the facts of Garcia's case. On March 31st, James Percival from DHS allegedly asked Reuveni if the government could argue in its court filings that Garcia was an MS-13 leader.
Was there any evidence for that claim?
Reuveni says there was no evidence presented to support it. And critically, DHS's own sworn declaration in the case, submitted by an official named Robert Cerna, actually conceded two key things.
Right.
One, Garcia had protection called withholding of removal, which legally barred his deportation because of fears of persecution or torture. And two, his removal was indeed an administrative error.
So DHS's own formal statement admitted the removal was wrong and he had protection.
Exactly. And Cerna, in that same declaration, also stated he could not personally confirm if Garcia even had any gang affiliation, let alone being a leader.
So Percival wanted to claim Garcia was an MS-13 leader, but DHS's own evidence didn't support it and actually confirmed the removal was an error. What did Reuveni do?
He stuck to the facts and the law. He kept pushing internally for updates on efforts to get Garcia returned from El Salvador and to ensure his safety in that dangerous prison environment. But he says DOJ leadership blocked these efforts. They allegedly told him he should only argue threshold jurisdictional arguments.
Meaning, again, try to get the case thrown out on technicalities without addressing the substance, the fact that Garcia was wrongly removed.
Precisely. Avoid the merits. Avoid the error. Just argue the court doesn't have power to hear the case.
This all came to a head in court, didn't it?
It did. On April 4th, 2025, there was an oral argument before Judge Policinas. Reuveni was arguing for the government. And based on the evidence in the record, specifically that DHS declaration, Reuveni truthfully told the judge that Garcia's removal was an administrative error.
He told the truth based on his own client's sworn statement.
Yes, he upheld his duty of candor to the court, but the fallout was immediate.
What happened after the hearing?
Reuveni says he started seeing news headlines about his admission of error. Then he got a call from Drew Ensign. Ensign allegedly asked him why he hadn't argued Garcia was a terrorist.
A terrorist? Where did that come from? The ask before was MS-13 leader.
Right. Reuveni explained to Ensign, look, that wasn't argued in our written briefs. There's zero evidence in the record to support calling him a terrorist, and the law wouldn't back it up anyway. Ensign then reportedly told Reuveni that these questions, why didn't you call him a terrorist, were coming directly from the White House.
Wow. Directly connecting the pressure to the White House. What was the final straw for Reuveni?
The very next day, he was apparently asked to sign off on an appeal brief in the Garcia case. This brief contained arguments he fundamentally disagreed with, arguments he believed were not supported by the law or the facts in the record, including, allegedly, that unsubstantiated claim that Garcia was a terrorist.
And he refused to sign it.
He refused. His reported words were stark. I didn't sign up to lie. Someone else at DOJ ended up signing the brief, and it was filed on April 5th, 2025.
And the consequences for Reuveni?
Swift and severe. Later that same day, April 5th, the day he refused to sign the brief, he was placed on administrative leave. The stated reasons were things like failure to follow a directive, failure to zealously advocate for the client, the government, and conduct prejudicial to your client.
But his refusal was based on ethical grounds, on not wanting to make arguments without factual or legal basis.
That's his position. The letter informing him of the leave, reportedly from Deputy AG Todd Blanche, contained a line that's pretty chilling. Every Department of Justice attorney is required to zealously advocate. Any attorney who fails to abide by this direction will face consequences. Reuveni was formally terminated just days later, on April 11th, 2025.
So after nearly 15 years of decorated service across administrations, he's fired essentially for refusing to make an argument he believed was false and unethical.
That is the core of his retaliation claim, yes.
Looking at all three of these situations together, the Alien Enemies Act case, the third country removals case, the Garcia case, what's the bigger picture here? What are the broader implications if these allegations are true?
Well, if true, it's not just about isolated incidents or rogue actors. Reuveni's disclosure alleges a pattern of behavior originating from senior DOJ leadership, potentially even involving the White House. A pattern of allegedly defying court orders, directing lawyers to mislead or make unsupported arguments, and actively suppressing information, all seemingly in pursuit of specific, aggressive deportation policies.
It raises fundamental questions about the integrity of the Justice Department.
Absolutely. And it's not just Reuveni saying this is wrong. You mentioned earlier 6 members of Congress have now written to the Attorney General and Deputy Attorney General about this. They specifically called out the Hobbesian choice this situation presents for government attorneys, forcing them to choose between keeping their jobs and upholding their ethical oath of candor to the courts.
Yeah.
They're actually calling for Reuveni to be reinstated.
What's the impact beyond the DOJ itself?
It's potentially huge. It impacts the safety and rights of the non-citizens directly involved, who might be removed unlawfully or without proper review. It impacts the constitutional separation of powers if the executive branch feels it can ignore or mislead the judiciary. And it impacts public trust in the legal system and the government's commitment to due process.
And Reuveni himself, despite being fired, he's obviously not staying silent.
No, he's clearly committed to bringing these issues to light. Filing this detailed disclosure is a significant act. It shows his resolve, sticking by his interpretation of his oath to the Constitution and the rule of law, even after facing serious personal and professional consequences.
So just to wrap our heads around this, we've gone through these really complex allegations stemming from this whistleblower, Reuveni, who, again, had this long track record serving different administrations.
Yeah, and the central conflict seems crystal clear. It's the tension between political or policy objectives, especially on something as charged as immigration, and the fundamental duties of lawyers, particularly government lawyers, to respect the courts and uphold the rule of law.
This whole deep dive, it really pulls back the curtain on those intense pressure points inside government, doesn't it? It makes you ask some tough questions about accountability, about transparency, especially when the DOJ itself is firmly denying these claims, calling them falsehoods from a disgruntled source.
It absolutely does. And it leaves you with this final thought to sort of chew on.
Sure.
Our whole system is built on checks and balances, right? So what does it mean if the very people sworn to uphold the law within the Justice Department are allegedly being directed to disregard court orders or bend the truth? What's the real cost when someone like Reuveni decides they can't cross that line and speaks out? And maybe more personally, how does hearing about these kinds of alleged pressures affect your trust in these vital institutions? How might similar dynamics be playing out, maybe less visibly, in other areas where policy meets